A very warm welcome to our first webinar of 2024, Road Crime and the Myth of the Lifetime Sentence, which is part of our Fix Our Broken Justice System campaign. I'm Sarah and I'm the Deputy CEO of RoadPeace, the national charity for road crash victims. We exist to support victims and to campaign to end road death and injury on our roads. The Fix Our Broken Justice System campaign was launched last year and calls for a fair and effective justice system, one that responds to road crime and crashes in a way that supports victims, delivers justice, and contributes to road danger reduction. One of the biggest problems we see is how often the justice system can aggravate the suffering of victims and how families so often feel let down by a system that does not take road crime and road violence seriously. And our webinar today is going to explore these issues and in particular look at the myth of the lifetime sentence. And we're delighted to be joined by a brilliant panel to help us explore this. A few notes of housekeeping before we get going. The webinar will be recorded and the video will be sent to everyone after the event, and attendees will be able to ask questions towards the end of the event via the Zoom Q&A facility. So I'm now going to hand over to Rebecca, RoadPeace's Head of Communications, who's going to chair our discussion and who will introduce today's panel. Over to you, Rebecca.
Hi, everybody. Thank you so much for being here, and thanks to our panel for being here as well. So today we're so pleased to be joined by Professor Sally Kyd, who's head of Leicester Law School. She's an expert in criminal law, specialising in road traffic offences. We are going to be joined by Detective Chief Superintendent Andy Cox from the Metropolitan Police. Unfortunately, he's not with us just yet. He's been called to something quite urgent as an operational officer, so but he will be joining us, I've been assured, as soon as possible, and definitely before it's time for him to have his say on some of the issues today. Thank you very much to Calvin Buckley, who's kindly agreed to be on our panel. Calvin, as you may know, his partner Frankie Julia Hof and their unborn daughter Neve were killed by a dangerous driver last year. He has bravely become a campaigner with RoadPeace, and we're really pleased to be supporting him and working with him. Polly Herbert, a road traffic injury lawyer, very passionate about this issue, and she was Calvin's solicitor throughout that case. And we're also hopefully going to be joined by Nick Atkinson KC, a retired barrister and part-time judge, but I think he might have a few technical issues at the moment. So hopefully one of the RoadPeace team can make contact with Nick. He, I think, has been trying to call me. So maybe somebody could call him, as I can't. That would be great. Okay, so we're going to ask a series of questions to get the debate and the conversation going. You may well have questions as attendees yourself, which you want to ask. We're going to make sure there's time at the end of the event, towards the end, for you to ask any questions you have using the Q&A facility within Zoom, which hopefully you're all familiar with at the bottom of your Zoom screen. But hopefully we'll answer lots of things already before we get to that point. So we're going to start with the burning question, certainly something that's been baffling me for some time, and I hope we can get to the bottom of it a bit more today. So the law changed in 2022. The maximum sentence for causing death by dangerous driving was increased from 14 years to life in prison. But the law couldn't be imposed until the Sentencing Council guidelines were revised. And then in 2023, a year since the law changed, those guidelines were finally released, and we thought everything was then in place. But despite seeing some horrifying examples of dangerous driving, so in the case of Frankie's that we've talked about already, we didn't see a life sentence, and we haven't seen one yet for causing death by dangerous driving. And I hope that Professor Sally Kyd, who's here today, can help us to shed some light on that. So Sally, over to you.
Thanks, Rebecca. I thought it'd be useful for the audience to have a bit of understanding of why I feel I can speak to this. As Rebecca said, I'm a professor of criminal law with an expertise in road traffic offences, but I came to this from the very worst types of cases. So I, earlier in my career, did a project on homicide, looking at murder and manslaughter and how they ended up as different convictions after trial. And I became interested in those cases where It was a motor vehicle that was used to kill. And I did my PhD on the investigation of fatal road traffic collisions. And we're going back now to the end of the last century, when I've read Nick Atkinson's blog, which I'm sure many of you have, and he describes there some of the changes that have come about in law. So things have changed massively since I did my PhD. At that time, there was only causing death by dangerous driving, and causing death by careless driving was under the influence of drink or drugs. And the maximum penalty was actually, yeah, it wasn't even 14 years then, it was 10 years. So when somebody committed careless driving and killed, literally, they just got a fine, penalty points. And obviously a lot has changed since then. But I understand that, you know, that it is difficult. I have always been of the opinion that when manslaughter can be charged, whether it's through a motor vehicle or some other way, it should be charged. And I was rather concerned when, you know, there was this proposal to increase the maximum penalty to life. And the reason I was concerned by that is that I was worried that bereaved families, such as those on the call, would be given false expectations about the sentence that would then be passed. And the reason why I say that is that if you look at sentences for manslaughter, you very rarely ever see life imprisonment given for manslaughter. So the fact that we now are in a position where the two most serious causing death by driving offences do have a maximum of life does not mean we will ever see, I think, a life sentence passed. And this is all to do with proportionality in sentencing. So, you know, murder is our most serious criminal offence in this country. It carries a mandatory life sentence. But that doesn't mean that anyone who commits murder gets life in prison. They get a certain minimum term that they have to spend in prison before they're released on licence. Now, manslaughter has that as the maximum. There are different species of manslaughter. I've just been lecturing to my undergraduate students, but you only ever really see a life sentence passed in cases where the defendant is seen to be dangerous because they are suffering from what's known as diminished responsibility. So they have a mental condition that makes them dangerous, and you occasionally see life imprisonment sentence for that type of manslaughter. But when we're looking at the sort of manslaughter that would equate to death by dangerous driving, which I think, as I say, manslaughter should be charged when it can be, not because of the sentence, but because of the way we label it. You know, killing with cars is no less serious than killing in other ways if the requirements of the law have been met. And I think there's, you know, it communicates kind of lessening of the seriousness of the offence if we label it differently. So I've always been of the opinion that we should be charging it as manslaughter when we can, and that in terms of road harm, what we want to be doing is increasing the sentence for the underlying offences such as dangerous driving, drink driving, because the psychologists tell us that we can only deter that underlying behaviour. Nobody ever thinks they're going to kill. They think they can get away with it. And so to answer the question, so first of all, I would just some clarification there. The courts didn't have to wait for the Sentencing Council to release their guidelines last year. There was a case before June of last year, I think it was reported in the spring of last year, known as Soto, where the Court of Appeal said that the courts could be applying the new maximum, but they were looking at the fact that, you know, the previous sentencing range only stopped at 14 years. And they said, well, you can go above that now, the law has changed for the most serious offences, but until we've got the sentencing guidelines from the Sentencing Council, anything at the lower end, you know, hold off necessarily increasing the sentencing range for those cases. And then we had the Sentencing Council obviously issuing their guidance, and we see that being applied by the Court of Appeal for the first time, as I understand it, in Frankie's case. So the defendant in that case, his name was Iqbal. That is now a Court of Appeal decision that will be referenced, I expect, in later cases. And we see there that actually what's interesting in that case is that the Court of Appeal is saying the court should be sentencing beyond the range that's currently in the guidelines. So I wanted to go back to the fact that manslaughter you never see a life sentence for manslaughter. If you look at the sentencing guidelines for manslaughter, there are different species of manslaughter. Gross negligence manslaughter, I would suggest, is the nearest and the most appropriate offence in most cases of causing death on the roads. And the sentencing, the starting point in the sentencing range for that species of manslaughter is the same now as for causing death by dangerous driving. So a starting point of 12 years with an upper maximum of 18 years. So you very actually rarely see examples of manslaughter at that upper end. I did look at recent, if anyone's interested, look at recent sentencing cases for manslaughter to see the sort of ranges that were there. So in Frankie's case, the Court of Appeal is saying that the starting point would have been 21 years, which is actually above the range of the maximum the Sentencing Council has laid down. But they're saying it's appropriate in this case because of the number of awful aggravating factors that were available there. But we have to bear in mind that in any case, if somebody pleads guilty, they will get a discount on that. Whatever the mitigating circumstances, they always get a discount. In that case, 25%. It could have been more if he'd indicated a guilty plea earlier, like when he first appeared in the magistrate's court. So I hope that gives some answer. I just want to emphasise that I can't see a case that would actually ever result in a prison sentence of life in a causing death by dangerous case, because if we compare it to manslaughter, we don't see it there either, as I say, except in the cases of diminished responsibility, where somebody is seriously ill and that they need to be kept away from the public. That's separate to the disqualification question, which I know we have questions on later. I'm happy to answer any follow-up or clarify as appropriate.
No, I think that's incredibly helpful. Thank you, Sally, at this stage to start this as we mean to go on and kind of set the scene there and understand that a little more at the start. So I just wanted to move on to the case of Frankie Julia Hof a bit more specifically. Obviously, we have Calvin and Polly here. So in May 2023, you may all remember the case of Frankie. Frankie and her unborn daughter were killed by a dangerous driver on the M66 in Greater Manchester. The driver had reached speeds of up to 123 miles an hour and was filming himself throughout the journey, holding the wheel with one hand and holding his phone with the other. What could be worse? What could be a worse example of dangerous driving? Frankie's two sons and nephew were also seriously injured in that crash. So as Sally's talked about already, as we may remember, the driver who killed Frankie was jailed for 12 years, and the sentence was later increased on appeal to 15 years. But I just wondered, from a family, victim's family perspective, from Calvin, from your perspective, can you explain how you felt when the driver who killed Frankie was sentenced to 12 years? As we know, that went on to be 15, but only because you had to go through that very traumatic appeal process. And even then, that 15 years still, as we saw it, I know Sally's just explained more about how the law works, but as we saw it, that still fell far short of that life sentence that we were perhaps hoping for. Can you explain a bit about that? I'm just trying to, there we go.
Yeah, sorry. So for me, that it was absolutely devastating once we got that verdict. The full trial, from a family point of view, it felt like everything was about getting the offender sentence lessened. So as Sally just spoke about the mitigating circumstances, the trial was mainly about that, and it was just seemed to us that the judge was focusing on, like I said, trying to get the sentence lessened. So as a victim, you don't feel like you're being heard or you're actually being supported. For us to leave somebody in that way, then go into court and basically it's like you're just watching them try and what's the word, lessen the sentence for that person, or trying to play down what had happened. None of us felt like the focus was on us, the family, the victims. You know, you're not really involved much in the full case. You're basically just witnessing it. You do have your impact statements, which you read out. Apart from that, there's not really any more involvement. You're literally watching two people like play to see who can score points, and that's basically what the defendants did. They just went down, and the judge took into account every single thing that they put up for mitigating circumstances. And the difference in the appeal was the way the judge handled the case and viewed the case. All the mitigating circumstances, he acknowledged them, but he also talked about the severity of the case, how it's impacted Frankie's family, her sons. You know, they focused on that side of it, which for us felt better and felt how it should have been done in the first place. We was quite lucky that the appeal was quite quick. I know for some people they could be waiting 12 months, 18 months, and just being left in limbo and hanging on. So we was quite lucky that we didn't have to wait that amount of time. But still, you know, the trial happens at a point where you're not in the best place mentally. You know, you're suffering from all sorts, and then for that to be prolonged and saying, well, actually, you're not getting the verdict you want here. Now you're going to have to go and appeal, and it just prolongs the agony, and it also stops you from being able to move on. Because we did get a bit of closure after that last case. Again, this actual sentence and what we thought would happen was the complete opposite. The case being so severe, a lot of people did think or was hoping that it would get a life sentence. And when we didn't get that life sentence, it wasn't about just punishing the driver. It was about acknowledging how severe this case, the impact it's caused and the damage it's caused to obviously Frankie and Neve losing their lives, and for us as well. So for us to have to hear that, then wait to go through the Court of Appeal, and then still, yet we did get a better verdict in the appeal, which, like I said, we was happier, more to do with how the case was viewed. And, you know, we felt that it was being, you know, people did actually see how bad it was for people. So that there was that, but still at the end of it, the life sentence didn't come. And then from that, the development is this whole myth of the life sentence, which we didn't know any of that up until the Court of Appeal. When we started, you know, the judge was saying it's the worst case. You know, you're not really going to get any worse cases. The mitigating circumstances can't be played into account apart from the pleading of guilty, which again is another debate that needs looking at, because he did plead guilty, but he didn't plead guilty at the very start. The first thing he did when he got out of the car and the police were speaking to him was saying that, oh, he thinks he's got something wrong with his tire. Then he refused to hand over his mobile phone. So, you know, he didn't plead guilty at the start, but because it was before the trial, he still got, you know, a quarter of his sentence off, which again, when the case is that bad and somebody's pretty much going to get found guilty anyway, then why are they still getting that time off for it? So by the end of that appeal, it, you know, speaking to people, they were saying it's not likely that somebody is going to get a life sentence for some of the reasons that Sally's just discussed. But we never knew that up until maybe October this month. So, you know, for 6 months, we're still going around fighting for this life sentence. And now at the end of it, it's like, well, actually, we don't think anyone's going to get that. So for me, all the families that have come before, all the people that have fought for that, they've been kind of lied to, given a token gesture of, yeah, you can get this life sentence, to say, we're acknowledging how severe this crime is, but then the reality is you're not going to get it. So that, you know, that is something that, if that's the same in manslaughter as well, and people are not likely to get it, then, you know, that needs looking at, in my opinion. Or don't have life sentences the maximum if they're not going to get it. If you're not going to get it, then don't say you are, because for us, it was the maximum sentence is what we wanted. Whether that was a life sentence, however many years, you know, I'm not going to debate how long these sentences should be, but we wanted the maximum sentence. And they're saying you can get it, but actually you can't. So I don't really understand that, and that has still left us feeling quite, you know, let down by the system, really.
Thank you, Calvin, for explaining that so well. And you always do speak so well about this, and great admiration. And, you know, our condolences once again, and thank you so much for being here today. There are probably other things as we go on that you may want to comment on. But I was just going to ask Polly now. Polly, you were Calvin's lawyer throughout this case. Were you surprised by the sentence that was ultimately handed down here to the killer, to the driver who killed Frankie in this case? And were you expecting a life sentence? I think a lot of us were poised, weren't we, for that verdict initially? And were you surprised?
I think I should probably first caveat by saying I'm a civil lawyer. I'm not a criminal lawyer. I have supported, unfortunately, many families through both the civil process and the criminal process, because there is overwhelmingly a lack of resources and support for victims of road crime, unfortunately. So I do kind of cross over into the criminal courts. My experience there was lots of talk leading up to this case for Frankie and her family that there had been this significant change in the law. There was talk about this significant change. There was talk about the fact that it was coming into effect just a mere couple of weeks before the sentencing hearing for Frankie. And there was a lot of attention on the case. We had, you know, a lovely young lady pregnant with her children and nephew in the car, you know, parked on the hard shoulder, and an erratic, dangerous criminal driver who had a history of doing this and had actually filmed himself in the process of the crime. So in terms of media interest and what could be expected, I think there was a little bit of a storm around things. And we tried as carefully as possible, and when I say we worked very closely with the family liaison officer of Greater Manchester Police. We tried as much as we could to manage the expectations of, look, there has been this change in the law. This potentially is the first case that's going to be heard that might actually tip the balance to a life sentence. But I think it very much the CPS, and I think the police, and in some respects the judge on the day, was set up to fail. You know, when I've had a look back now on the reasoning in respect of the sentencing that was given in the first instance, but also the Court of Appeal, I've had a look at the government consultation papers back in October 2017. And forgive me, I've just got it up in front of me, but I think it is important that when the government announced this change, it was said life sentences will be introduced for those who's caused death by dangerous driving. Part of government's action to make the roads safer for all and stop devastation caused by dangerous driving. Killer drivers face life behind bars after plans to increase maximum sentences receive resounding support from families and campaigners. Ministers today confirmed drivers who cause death by speeding, racing or using a mobile phone could face sentences equivalent to manslaughter, with maximum penalties raised from 14 years to life. Now, something happened between that government consultation in 2017 and the actual drafting of the sentencing guidelines, where then there was a change which said, effective from the 1st of July 2023, the offence range was 2 to 18 years in custody. So it then says maximum life imprisonment for offences committed after the 28th of June 2022. So there is just a lot of confusion in terms of what the government promised to campaigners and victims and members of the public and announced back in 2017 compared to what was drafted in the sentencing guidelines. So after the first hearing, everyone was actually quite shocked at the level, regardless of the change, because the driving that Mr. Iqbal undertook that day was prolonged. And there was many talks, and there was, Calvin's family was supported in terms of what the expectations could be going to the Court of Appeal. And the judges were fantastic. And the Attorney General's office sat down with Calvin and myself after the hearing and tried to go some way to explain why a life sentence wasn't applicable in this case. And we were basically advised that the only foreseeable case that they could envisage going forward was if somebody had killed somebody on the roads, been convicted of causing death by dangerous driving, served a sentence, been released from prison, gone back out on our roads and killed for a second time. That was the only time that they could envisage a life sentence. So, sorry, going back to your original comment about, where are the expectations? How are we as professionals, as campaigners, as, volunteers or safety charities, how are we meant to manage expectations of families who are going through an awful period of crisis and trauma when there is no clarity in the law? And I think the campaign just starts again, unfortunately, and clarity is needed.
Thank you, Polly. I think that helps to look at that bigger picture as well. And looking back, like you say, that build up as waiting, RoadPeace as a road victims charity, waiting and waiting for that and expecting, and then obviously that was dashed in reality. Nick Atkinson, KC on the call. Thank you for joining us. You were a barrister for almost 50 years and a part-time judge for 35. Looking back over your career and where we are now, has the law got tougher on road criminals, do you think, over the years? And why do you think that road crime is perhaps still being dealt with more leniently than other crimes?
Can I also say something about the Sentencing Council? Because this is what's intervened between Parliament passing the law, increasing from 14 years to life, and then you get the Sentencing Council. Now, the Sentencing Council were established some years ago as a result of ridiculous sentences that always get publicity. I mean, most sentences aren't too ridiculous, but there are some that are completely absurd. And politicians said, right, we'll have a Sentencing Council. And the Sentencing Council should introduce guidelines, and it should also perhaps get greater uniformity of sentence across the country. Wonderful idea. The impression was created, I think, by the politicians that it was going to toughen up sentences because it was created as a result of complaints in the press and in Parliament about too lenient sentences. In fact, it hasn't. Across the board, not just in matters relating to motoring, but all sorts of cases, it has reduced the level of sentencing. And this is a classic example where in death by dangerous driving, Parliament has said, the maximum sentence is life imprisonment. That's the statute. But what do the courts look at now? They're encouraged to look at the Sentencing Council guidelines. And the Sentencing Council, there may be very intelligent people on it. I've looked them up recently, a couple of days ago. There are about 14 members on the Sentencing Council. The first name one comes across is the new Lady Chief Justice, whose practice was in commercial law. She's a very intelligent woman. She's got an enormous amount of work to do. How much involvement she'll have with the Sentencing Council, I would speculate, will not be very much. And then you go down the members of the Sentencing Council, and there are judges and circuit judges, and in particular the two Lord Justices, which is another higher level of judge, who sit in the Court of Appeal, and a circuit judge. Those three, for example, have all been taking part in judicial studies. It's interesting to note that those who are involved, who give up their time to run judicial studies, it never seems to be a hurdle to their progression in the legal system. Judicial studies is in fact judicial training, but they always thought when that was introduced 40 years ago that judges might not like the word training, so they call it judicial studies. They may be the most persuasive people, I don't know, on the panel, because they're people who've been telling judges how to conduct themselves for years. And this classic example of watering down the sentence, they say this is the worst case they've heard. For example, I think from press reports, the Court of Appeal, Mr. Justice Bean, I suspect, who was presiding over, or Lord Justice Bean, who was presiding over the Court of Appeal, may well have identified as the worst possible death by dangerous case that they ever dealt with or heard about. Why is the Sentencing Council saying, well, in the very worst sort of case, the ban should be up to 18 years? No, Parliament said life imprisonment. And if they're going to reduce it from life imprisonment to a shorter term, that's where they should be starting, at life imprisonment, not 18 years. And the 18 years as the top tariff, as it were, for the worst case, you then have Parliament being tough, saying death by dangerous, life imprisonment. But Parliament also says, on the other hand, if you plead in the court the first opportunity guilty, you could get a third off your sentence. Now, I don't know how the first judge calculated 12 years, but if he took 18 years as the top sentence and then takes off 6 months because of the credit for the plea of guilty, taking off a third on the sentence. In the sentencing council's advice, they say sentencing guidelines must be followed unless the court is satisfied that it would be contrary to the interests of justice. And that's where you get the concept of this discount. So Parliament saying on one hand will be tough, and on the other hand they say, oh yes, but if you plead guilty, that will save time and expense and trouble and witnesses having to attend. You can have up to a third of your sentence. The sentencing guideline also, in passing, says, unless the court is satisfied, it would be contrary to the interests of justice. It's absurd to reduce the sentence in this sort of way. And, you know, in the interests of justice, what alternative was there but to plead guilty? This was somebody who filmed his driving, dangerous driving, up and down a road, overtaking, undertaking, speeding at a ridiculous speed. How could he do anything other than plead guilty? And how does that qualify for something? And that's why I would suggest that the court would be thinking that it could be contrary to the interests of justice. Everyone's got a different idea about what justice means, but it surely falls short in this case that the general rule being life imprisonment is the maximum sentence. And I can understand the frustration and disappointment, real disappointment, of members of the public who know the law's been increased and somehow feel they're let down by the system. It's not only death crashes, but the full horror of a death crash and the awful circumstances of this particular case. And we've got to remember, it got publicity because of the somewhat celebrity status of the victim. You wonder what's happening every other day up and down the country with cases where people aren't fully aware of what could and couldn't happen in regard to sentencing. There is one excellent person on the panel who I've got enormous respect for, but the others on the Sentencing Council, one wonders how much experience they had of death by dangerous driving. The first, the judge who presided over the Court of Appeal, I mean, his practice didn't concern criminal law. I don't imagine he ever did a case of death by dangerous driving. As far as the sentence being increased, as you know, from 14, the maximum sentence being increased from 14 years to life imprisonment, if you go back 30 years, believe it or not, the maximum sentence was 5 years imprisonment. 1991, 5 years imprisonment. And the law is needlessly complicated now, because in that time, there was only one offence of death by dangerous driving. There are now 3 or 4 ways you can be before the court for causing death. It would all be much more straightforward if it was motor manslaughter and you killed somebody and you dealt with seriously by the courts. And why it's important to have life imprisonment as the maximum sentence is because this isn't a road traffic offence. This is a homicide, and it should be treated in that way. And one of the advantages, I hope, of it being a life sentence as being the maximum is that you don't have it tried by part-time judges, such as I was. You have it tried like you have murders tried by High Court judges or people who've been given a special ticket to do. And a lot of the judges at the Old Bailey have tickets to try murders, but generally it's High Court judges and occasionally the resident judge in some court centre. It's a question of increasing the significance of it, not treating it as traffic. That's the reason why it's life imprisonment. You get a better, hopefully, more thorough police investigation. You get better and more senior people at the Crown Prosecuting Service considering the evidence and appropriate charge. And you get a better tribunal to hear the case. And indeed, you start getting advocates who are on a better, it comes down to money in the end, a better pay scale than if what happened in the 80s, having somebody being paid, a barrister being paid the same as if he was prosecuting a shoplifting case. Because theft is 10 years, but death in the 50s was 5 years. Yes, it has to be re-examined. We have to keep campaigning.
Thank you, Nick. That was incredibly useful. Thank you for giving your take on that and sharing that from your career. I'm just looking at the time. We've got some questions to answer from attendees, which will be great. We'll move to those shortly. But I just wanted to. I think it'd be wrong of us not to briefly touch on driving bans while we're here, because again, another very important part in terms of seeing justice done. You know, if someone kills, death by dangerous driving, why should they ever drive again? But obviously people frequently do. The courts have the power to impose lifetime driving bans for dangerous drivers, but we rarely see them imposed. And why is that? Why should people ever be able to drive again? Why should victims, families see that person driving again? Why should they have their freedom back? And I think it comes back to that driving being a very great privilege and not a right, which it is often wrongly seen. So Sally, Professor Kyd, is there anything you may want to say about driving bans? You know, why aren't we seeing lifetime driving bans being imposed?
From my understanding, this is down to what previous courts decisions have said, and the fact that I think we are seeing a change with these types of cases being accepted as being more serious than they were viewed many years ago. But we haven't seen that. We started to see a change I think, in the Sentencing Council's response to their consultation on this. But essentially, I'm hoping to look at this in more detail in my next research project. So my previous research projects have looked at, you know, the police and CPS decision making about charging which offence to charge, and I've looked at more than 600 fatal collision files. but I wasn't focusing on the sentencing. It was more the earlier decision making. What I want to do is look at the sentencing side of things, and as much well, more actually on the disqualification question, because I think what Nick said was right about the Sentencing Council. It's been introduced in order to try and assist to make sure we have consistent sentencing across the country, that it shouldn't depend which court a case is heard in. There should be a very consistent approach to the sentencing being applied, but the Sentencing Council has declined to give detailed guidance on how long somebody should be banned for. And I'm interested to know, I think we don't know enough to begin with. We don't know how consistent courts currently are with how long they ban. But we do know, yes, they very rarely apply a lifetime ban. And that, as I say, goes back to previous Court of Appeal decisions. There was one called Cooksley, where they talk about the guidance should be that somebody's banned for no longer than is necessary. Well, the question then becomes, what's necessary? And I don't really understand this reluctance of taking away the privilege. As we've said, it's a privilege and not a right. So I'd like to do some more research in how judges come to that decision of how long the ban should be, beyond the minimum that is required for specific offences like causing death by dangerous driving. There was one case that went to the Court of Appeal where a lifetime ban was given, and that was the case of Noble, reported back in 2002, which again, really awful circumstances in which somebody was killed on the roads. But the Court of Appeal did accept in that case that where somebody is seen to be a danger to others on the road indefinitely, so this was somebody who didn't just have 1 or 2 previous convictions, but they had a whole host of previous convictions for driving offences and had been banned previously and driven whilst disqualified, etc. And the court in that case said it was appropriate in those circumstances where it was seen that this person would be a danger on the road if they were allowed ever to drive again, to ban them for life. Why that's not seen more often to be appropriate, I'm not sure, other than the criminal justice's view of, I think it, for me, and my understanding of it is that the problem is with our society. We are driven by this car culture within this country. People do see it as a right to drive on the roads. People can't imagine having a successful life without being able to go wherever they want, whenever they want. And I think that's the problem. And there's this idea that if you ban somebody for life, that's going to prevent them from being rehabilitated going forward. So part of the court's aim is to rehabilitate offenders, whatever the offence they've committed. And there's this idea that, if you ban them for life, that's going to prevent them carrying on or being able to have a career, hold down a job. I mean, that just, again, I think that reflects our culture, that there's this idea that you have to be able to drive. Well, there are plenty of people who can't drive for lots of different reasons, who are able to hold down jobs. There's no reason why being unable to drive should mean that somebody can't carry on a valuable existence and contribute to society in a positive way. And I think we've started to see a shift there, because we have seen that the courts and the Sentencing Council are now accepting that disqualification from driving is part of the punishment. It's not just, in the past, they've just seen it as something to try and prevent future harm. So we need to ban driving because somebody might cause future harm. And yes, that is an issue. But now it's accepted that it can form part of the punishment in addition to the prison sentence, which would, I think there is a case to be made that lifetime bans are the way, should become much more common and should be perhaps the standard, particularly in a case that falls in the highest level of culpability for causing death by dangerous driving.
Well, certainly from a deterrence perspective, that's got to help. If people are seeing those press reports that people are losing their licence, then surely that may act as a deterrent against future offending.
I'm not convinced by that, and I did mention that earlier, and I've seen in the question somebody's asked me to elaborate a little bit more on that. That psychologists have said you can deter the underlying behaviour, but not the causing death itself. The problem with these people, as in the case of Frankie, is they do this all the time. Every time they go out and drive like in a way that risks everybody else's lives, and they don't have a crash, their behaviour is reinforced. And they see, what psychologists have found is that drivers see the rules of as applying to everybody else who might not be as good at driving. You know, they're really skillful. They can ignore the rules of the road because they're such great drivers, and they can drive at 120 miles an hour, whatever. And until it's too late, they don't get that yes, this is a law that applies to everybody, and they don't get that they could kill somebody. And because they don't think that they could kill somebody, they're not going to be deterred, whatever the sentences that we have. So that's what psychologists have suggested, and I think I think it makes common sense as well. So people need to think that they're going to get caught from, you know, the first time they go out on the roads and they're filming themselves driving at stupid speeds, and that if they are caught, they're going to get a serious sentence, and that's what we can try and prevent through sentencing. I can't see. And the other point is, obviously, people don't know that they're going to kill somebody else. They might kill themselves. And if they're not deterred by their own life being at risk, why would they? I mean, personally, my focus would be on the fact that it's up to you whether you risk your own life. We've got to prevent harm to others. But lots of these people are very selfish and inward looking, and they're not. They don't have that mentality at all. So yeah, I do think it's the underlying offences that require more stringent sentencing, as well as perhaps causing death offences.
Thank you. Thanks for that, Sally. I'm just going to move across to some of the questions that we've been asked on the Q&A. We've got a lot, and we've got lots of comments as well. So thank you to everybody. Unfortunately, I doubt we're going to have a chance to answer all of them. But we'll make a start, and any that we don't answer, we will try and get the answers from our panel and send to everybody who registered today. So we've got somebody anonymous here says, hi, we were told that our case would be brought to the CPS in January for them to make a decision to charge with death by dangerous or death by careless, and we've still not heard anything. We assumed it would be the beginning of Jan, as this was said before Christmas. Where do we stand with this now? Are we allowed to keep pushing the police? Does this work? Or does this hinder things? We do have the added difficulties where the offender is a foreign national and may not return to the UK for sentencing at all. Can anyone add any insight into this? Is this anything you could comment on, Sally? Or
yeah, I think I would keep pushing. My research looking at these offences, but also offences, the underlying offences, it's that the relationship between the CPS and the police can be quite difficult. I think, you know, the fact that the police have family liaison officers now, it's a much better position than when I did my PhD, for example. So I would go back to the police. I've seen a lot of change in the CPS, and I think this does go back to underfunding of our criminal justice system. People on the call will have seen this in relation to causing death by driving offences, but it is a problem across the board. I think that the CPS are underfunded, and I question whether, I mean, Nick alluded to this earlier, do we have Crown prosecutors in place now that have a good understanding of the law, and who take on these cases with experience of prosecuting them? Because at various times during my career, my research has suggested that is good practice, and that's what works best for victims' families. Having interviewed Crown prosecutors 10 years ago, following on from my PhD, and I think there is postcode lottery there as well. Those CPS areas where they had identifiable prosecutors who were expert in this field and would meet with victims' families and be very careful about that open communication. That was best practice, but I'm not clear on whether that, and in the current situation, given the lack of funds in the CPS, has continued at all. And I'm sure there's people on the call who could comment on that with their own experience. But yeah, I would keep going back. I mean, some of these cases, they will take months, if not years, and this is part of the problem with the criminal justice system, as I say, as a whole. It's not specific to the harm that we're looking at, but I think it has particularly serious consequences for bereaved families as a result. So yeah, keep asking the questions, make a nuisance of yourself, I would say. Because I can see, you know, you're going to want to get answers one way or the other.
Thank you. I hope that helps that person that asked that question. We've got a question from Susan. Sorry to read this, Susan. My son was killed by a driver travelling at 50 miles an hour in a 30-mile-an-hour zone. He was on a well-lit crossing on a wide road. His case has been with CPS since July. I think they are still deciding if it's careless. It's the not knowing what's going on that's destroying me. The driver is still earning a living after killing my 19-year-old 18 months ago. Nick, would you like to make a...
Yes, I think this is an area where there is almost a postcode lottery as to the competence of the local CPS. And one of the really terrifying things you mentioned just now, they're thinking about whether it's careless or dangerous driving. Careless driving, causing death by careless driving, can attract a sentence of maximum sentence, according to Parliament, 5 years. According to the Sentencing Council, 4 years. The gap between 5 years maximum and life imprisonment maximum is clearly enormous. So who decides whether it's careless driving or dangerous driving? The CPS in an office behind closed doors, they make a decision. That is deeply unsatisfactory and should not be the case. In answer to the person who wants to keep pushing, you've got to keep pushing. Push the police, push the CPS. I believe that the Sentencing Council are going to look at the issue of disqualification. You might be surprised to hear I've got no confidence they'll come out with anything very sensible, but who knows, that maybe they will. That's all.
Thank you. Thanks very much, Nick. I've got a question from Ian Greenwood. Hi, Ian. Thank you for asking. Calvin says the priority in his experience was to reduce, and that was my experience in my case. Whilst those in the justice system carry on debating, the lack of priority for victims, hearing our voice and parity remain troublesome. As the war on the motorist dominates the current discourse, what practically can be done to change the position? We only ask for fairness. Has anybody got anything from the panel on that?
Well, fairness and justice is what's meant to be the service provided by the courts. And of course, there is this facility now given of the personal statement that can be made and dealt with, heard in the court. And I think when it was initially introduced a few years ago, I was rather skeptical about it because I thought, well, the judges have got some experience of these things and how people suffer. I've changed my mind because however much you deal with things in court, it's all a bit of an antiseptic atmosphere in court, and it's always a little bit away from reality. And the victim statement brings the court back to reality. They like to deal in courts and say, well, we don't want to be too emotional. Well, yes, you've lost a partner, a child. It's not surprising you're emotional. And the victim statement should be read, ideally by the victim. If they're not prepared, not willing to do that, they can make the statement. It can be read by the lawyer. It shouldn't be a question of the judge saying, well, I've considered the victim statements. It should be read in open court. to bring some reality of what the real suffering is. This applies in all cases, and certainly applies in cases where there's been loss of life.
Just on that point, actually, Nick, am I okay just to pick up on that, on some recent things that I'm seeing supporting families through the criminal justice system? There is a worrying trend of court time and availability, and we are seeing a suggestion that the victim impact statements are read out abridged. And it's very important, if any families are on this call that are going through the criminal procedure now, if you haven't been provided by a family liaison officer through the police who are investigating, you should be, but if you haven't been, ask for one. And your family liaison officer will be able to advocate for you at any criminal proceedings to ensure that your full statement is either read completely by yourselves if you want to, and they'll provide you with support to do that, or they will ensure that they speak with prosecuting counsel to ensure that your full statement is read out. But the very fact that we're now even scrimping because of court time, and what seems to be an acceptable way of reducing court time is to reduce a victim's voice, is absolutely shocking.
Can I just comment on that as well? For us as well, in the trial, you know, the impact statement is the only part of it where you said where our voices was actually being heard, and you know, we did feel that that was, like Nick was saying, bringing it back to reality, because it is very factual and trying to lessen sentences and stuff, and then all of a sudden it stops and you get the family's opinion and what they're going through, and for them to lessen that or try and, you know, devalue that part of it, that is the only part from us where we actually felt we had any involvement or any influence on the case. So to take that out of it, you would literally just be watching everybody decide on what happens in your life and the severity of it. So for me, that would be devastating, because, you know, we did do our statements, and as difficult as it was, I wanted to read it out myself for maximum impact on people. So that hearing that is quite worrying, really, and a bit devastating for other people and other families that are going to have to go through this process that we went through.
Thank you. Thanks for that, Calvin. Useful to hear your views as well, Polly, on that. We're getting quite low on time now, and anyone who has asked a question that we've not answered yet, we will certainly send them to our panel to get a response. So don't worry if we've not been able to cover them all today. I'm just checking if we've got time for one short question. I don't know if we can be really snappy with a minute answer. Does anyone have any data how often police use pre-charge bail conditions to prevent a driver who has killed but not yet charged from driving? Sally, do you have anything snappy on that?
No data that I'm aware of at all,
No.
But it's a good point and relates to something else. You know, that's the way to get the drivers off the road once they're under investigation, would be as a bail condition, and I don't think there is that sort of data is collected.
No. Okay. Thank you for that. I just want to end really with somebody's comment here, which I think puts it into perspective. Considering you can get up to 7 years in prison for selling a plant, cannabis, that can't kill anyone, this animal, presumably talking about Frankie's case here, took 2 lives and killed himself doing it, and only getting 15 years. How does that make any sense? And I think a lot of people here will probably share that view too. I just wanted to thank everybody for being here today. Thank you so much to our panel. I think it's been such an interesting conversation, and it's certainly answered a lot of questions that I think probably many people had, clarified some things and given us some thought on how we can move forward with some of this. Just to let you know, again, anyone who asks a question, I'll make sure all of those are taken off that we didn't answer, and we'll put them to our panel by email, and we'll get some responses back, which we'll share with everybody. We recorded the session today, so we'll make sure that that all gets shared with you after today as well. We've now got a petition on our website to support our Fix Our Broken Justice System campaign. So if you feel strongly about this, please do sign that. It will mean we keep you up to date with things, and it will just make us feel like we're all doing something. We're pulling together on this issue, which we all feel so strongly about. And I just wanted to say thank you. So thank you, everybody. Thank you so much to all our attendees. Thank you for the views of our panel, and we look forward to seeing you at another event like this soon. Thank you.